Okay, we have a guest speaker that will be joining us about a little bit, about 35 minutes. So I want to get kind of some of the preliminaries out of the way. He's a professor here at Cal State Fullerton with his expertise in criminal law. Former deputy district attorney. We'll be talking about the kind of right of privacy on devices. This is the organization of our classes for the spring and summer in this topic. In the spring, we have 3 classes. This is the second one, history, major constitutional provisions, and contemporary constitutional issues. And in the summer, we go more history, more constitutional details, and we delve about the constitutional role of the Supreme Court. That comes in the summer. Today, we'll talk about some of the compromises made at the Constitutional Convention, and we'll do a 6-minute excerpt from an interview that we'll have in greater length in 2 of my classes. Next week, part of it will be in the Trump presidency class. We talk about the powers of the Congress and the limitations in the Congress to investigate the presidency. And then this class, in about a month, will have the rest of the interview. Professor Max Dery will join us in a few minutes. But first, let me start with this topic. And this is Professor Tom Campbell, former dean of the Chapman College School of Law, still a professor over there, former congressman, former a lot of things. Doctorate in economics from the University of Chicago, law professor at Stanford University, presidential fellow, congressman from California, from the Silicon Valley, state senator from the Silicon Valley, director of finance for the state, and at one point was dean of the School of Business at UC Berkeley. So I went over, and here's just an excerpt of the interview. I asked him about the emergency powers of the president, and that will be this excerpt.
There may be other examples that will occur in the next few months or years regarding the president's use of emergency powers. And he wouldn't be the first, I'm sure, but
no,
can you take us through why the president has emergency powers and how it can be used for something that appears to have at least not a majority support, at least in one of the houses?
You're quite right to say it's a delegated power, but it is also an inherent power. So let me begin by saying there are powers the president has that are inherent in the office of the presidency, whether Congress speaks to this or not. A silly example, not a silly, it's a very serious subject, but an example that is so simple that it's clear would be the president decides to order the U.S. aircraft carriers that were coming back to Pearl Harbor not to go to Pearl Harbor after December 7th.
Yes.
We were very fortunate that most of our aircraft carriers were at sea. So President Roosevelt orders them. Did he have the inherent power to do that? Of course he did. Yes. If Congress had attempted to say, oh no, you cannot move aircraft carriers out of harm's way, Congress would lose in any jurisdiction where the issue came up. So before we deal with the delegated power, understand that the president has inherent powers. Another example is President Abraham Lincoln. So Fort Sumter is being blockaded by the artillery of the state of South Carolina, and he decides to resupply Fort Sumter. Did he have the authority to resupply Fort Sumter? The Southern point of view is no, he did not, because he was putting federal troops into what they claimed was their sovereign state. But every serious scholar says, of course he did. So those are inherent in the president, whether the Congress spoke to it or not.
Okay.
In the case of the wall, the issue would be, President Trump would argue, that we are subject to an invasion. It is not an invasion of an army, but it is an invasion, nevertheless, of individuals attempting to enter our country contrary to the laws of our country. The president would make reference to caravans. He would make reference to the harm that comes from individuals crossing in this manner. And he would analogize it, therefore, to an attack on the United States, where he would have the inherent authority. And whether he would succeed or not in that argument might be resolved at the Supreme Court level. Now move to the delegated.
Yep.
So Congress also has the authority to say to the president, we understand there will be many times when you'll have to act in areas where Congress could be involved, and rather than put you to a difficult situation of having to get our approval and delay, we hereby delegate that authority to you. And in two respects, Congress has delegated that authority. In 1973, Congress recognized a general right of emergency powers. But there have been many, many times before that. The International Emergency Economic Powers Act, for example, is used by presidents, back to World War II, no, back to World War I, its predecessor, to deal with assets of an enemy power. So the United States, for example, nationalized, took over the Bayer aspirin company, because Bayer was a German company in World War I, and that's how aspirin was available for everybody without having to pay for the patent that Bayer held, Bayer aspirin as we would call it. So the president has this authority inherently in one theory, and the other is whether or not he does, the Congress can delegate. And in 1973, Congress said, henceforward, here are the steps that you'll have to take in order to declare an emergency. And they're pretty easy. Just announce it and put it in the Federal Register and inform Congress. Then later in the 80s, the Congress explicitly said, we know you're going to be spending money for military construction, military construction. And we're going to approve it for particular things, such as building out this fort or building out this air base. But we also understand that you'll have the occasion in an emergency where you can shift money, any money, including for military housing, that's what the statute says, over to any other military construction you wish that you think is necessary in the emergency. And that's probably the statute that the president will use. He will say there's a fair amount of money available for military construction. We presently have the military on the border. The military is engaged in building a fence or repairing a fence, and therefore I will use my emergency power, as Congress has delegated it, to build a more substantial fence, call it a wall.
Both houses of Congress could take away that authority, but maybe not one house of Congress. Is that how the
correct?
Your understanding of the law?
Well, not only, yes, indeed, you're correct, but both houses of Congress could be vetoed. So the Supreme Court has ruled in a case called Buckley versus Vallejo in 1983 that a single house cannot have the effect of Congress. You cannot have a legislative result from a single house. So, yes, Congress could pass a resolution, a House could pass a resolution saying, this is not a real emergency, we hereby take it away. And it goes over to the Senate, may not pass. Then it has no effect, President Trump can continue. Or let's say the Senate agrees, President Trump vetoes it. Now it requires 2/3 of the House and 2/3 of the Senate to overcome it. So practically speaking, barring a very egregious instance, the president abusing the concept, the president gets to interpret what is a national emergency and to redirect military construction money for that emergency.
So that's one view, and I have to say that that interview occurred before the president took the action, so he didn't have an opportunity to actually see the presidential what authority he used on that. But he also published earlier in this year an article in the Orange County Register, where he usually writes an op-ed column on most Tuesdays on constitutional and economic topics. Now, the House has approved House Joint Resolution 46 that says in part resolved that pursuant to Section 202 of the National Emergency Act, the national emergency declared by the finding of the President on February 15th in Proclamation 9844 is hereby terminated. And it passed the House February 26th. Now, yesterday, Majority Leader McConnell in the Senate said there's enough Republican votes, not his, but enough Republican votes to pass that resolution. And under the rules of the National Emergency Act, it is a privileged resolution that it must come up by so many days. So it can't be filibustered, or the majority leader can't not move to it. So it must be acted upon by March 15th. But in neither the House nor the Senate is it contemplated that 2/3 vote is going to occur. So what will happen? Well, it's hard to tell. Some scholars, legal scholars, have taken the position that the statute itself may be unconstitutional or unconstitutionally vague. But the way the president did it, is this a military action or a police action? A police action is prohibited by statute. A military action, of course, is not prohibited. An emergency is not adequately defined in the statute. So the courts, if they wanted to split the baby, could declare the statute unconstitutional, not the President's Act. So we'll see as it goes up to the Supreme Court. We'll obviously go to. Let's do a quick history lesson, and I don't think I'm going to complete it by the time Professor Dery shows up, and that's okay. We'll go to him. And we expect to lose the video any time now. Remember why we went to a constitutional convention. The Articles of Confederation that were adopted I think it's the Second Continental Congress, it may even been the first. I think it's the Second Continental Congress. Required almost unanimous action by each state to approve things like taxation, primarily through tariffs and other import duties, or to ask them to call up the militia for a particular federal duty, or to have a continental army. You had to get everyone on board, and consequently, things weren't getting done. So James Madison and others got together and said, we need to amend the articles. Actually, probably replace the articles. And there's much more historical detail, but I'm giving the highlights of this. And he convinced George Washington, in retirement from politics, to preside if he could get enough parties to agree to have a meeting to consider amending the Articles of Confederation, and eventually even got the Continental Congress that under the Articles of Confederation to call for the states to send delegates to this meeting in Philadelphia, in the same room that the Declaration of Independence was declared. George Washington was probably not a great presiding officer, but was the marquee name you needed to make this happen, because some, like Patrick Henry, called for Virginia and other states not to send delegates. He said, I smell a skunk. I smell a skunk. But George Washington, by going, provided great public service. And they met in private. The idea that there wouldn't be any knowledge by the public of how they were amending it until they had something that they could vote on as a final package because of the need for compromises. And early on, the delegates decided they can't, amending the articles was not the objective needed to make a country that could withstand the times. They needed a whole new document. So they decided to come up with a whole new, what's known as an organic document called a constitution. Because each of the states were different in in size. Yes?
What year was this, Mike?
Yeah, one of those years. One of those 1780s.
1787.
1787, thank you. Because the states varied in size, economic interests, and property interests, that is, slavery, it seemed very difficult to get a document approved that would meet the test of all those. I believe they needed 9 of the states to agree to ratify it. And of course they needed the big states. They needed Pennsylvania, they needed New York, they needed Virginia to make it happen. They needed Massachusetts. So delegates needed to compromise or abandon their efforts, and perhaps the goal of a single country. And one of the key decisions that was made was not to send it back to the Continental Congress for ratification or to the state legislatures for ratification, but to send it to the states to have ratification conventions in which they could decide who would come to those conventions, but it wouldn't just be the vested interest in each legislature. For example, in New York, the overwhelming majority of people going into that ratification convention were opponents, including the governor of the state. And that we'll talk about in the summer, how it got ratified. Ben Franklin said at one point, famous statement, 2 famous statements, when you assemble a number of men, and they're of course all men, to have the advantage of their joint wisdom, and you inevitably assemble with those men all their prejudices, their passions, their errors of opinion, their local interests, and their selfish views. From such an assembly can a perfect production be expected. So what did they come up with? Well, some highlights. They decided the president would be selected, the head of government, the head of state, in a single person, through an electoral college, based on congressional representation in each state. So if a state had 3 members of the House of Representatives and 2 senators, and they all had 2 senators, it would be 5 electoral votes. They had just 1 member of the House, and the 2 senators, it would be 3. That was a compromise. They come up with a system called checks and balances, written a lot in the Federalist Papers. We'll talk about the Federalist Papers more in the summer. Checks and balances on governmental power, the central government power. They were very concerned that by having a central government, it would be too powerful. It would overwhelm the states. It would take away their liberties. The whole revolution would have been fought for nothing. So separation of power among the 3 branches of the central government, and among the central government, the individual states, and the people. Came up with a concept that was well known in the English-speaking world of a legislative and an executive and a judiciary. The Great Compromise, as it was called, was how should the states be represented? And the plan that was eventually accepted was the so-called New Jersey plan, that would have these 2 houses of the legislature, of Congress. One would be based upon population, and one would be based upon each state being equal. The Congress, broad powers would be enumerated or limited. Congressional powers of this new central government would be limited to those enumerated in the document, with this big flexible clause called plus what's necessary and proper for executing those enumerated powers. Now, at first, they didn't anticipate the Supreme Court was going to make those decisions. They thought it would be made politically between Congress and the executive through bargaining, political bargaining. It was only later that the whole idea of the Supreme Court being the arbiter. At one point, in the initial years of the Republic, it was that the president could declare an act of Congress unconstitutional. The Congress could declare an act of the president unconstitutional. They all had these checks and balances. The congressional authority, of course, included taxation, spending, and war power. That even a military would have to be a central government military instead of the state militias, would have to be authorized by Congress. And it's how it's organized, how many members, its primary officers, its we call flag officers or general officers, would have to be approved by Congress. Its budget also gave Congress and not the president, the ability to initiate changes to the Constitution. And it indicated that any action that is vetoed by the president could be overridden by a 2/3 vote of both houses of the Congress. And importantly, though never used successfully thus far, the power to impeach or indict by one house and the power to try to a trial in the other house, with the trial presided over by the Chief Justice of the Supreme Court. So let's look at the House. This is stuff that many of you remember, but let me just make sure we all have a common factual basis. House elected every 2 years by popular vote. Representation determined by population through a census taken every 10 years to determine the allocation of congressional seats. All revenue bills have to originate in the House of Representatives under the theory that those folks, all revenue bills must originate in the House of Representatives and can initiate the removal of the president through the power of impeachment. The Senate, elected for 6-year terms, with 1/3 elected every 2 years. So the first Congress had people with 2-year terms, people with 4-year terms, and people with 6-year terms to start that process. Originally, it was only going to be elected by state legislatures, not by the people. It wasn't until 1913 with the 16th Amendment was direct election of the senators. And the first Congress of the United States, held in New York, with the Senate meeting upstairs in the federal building there, and the House in the downstairs, the Senate had their doors locked. And that's why it's also called the upper house, because it was literally the upper house. These were the so-called wise men. 2 senators per state, no matter the size of the state. And the Senate has to approve important presidential actions. The term is advise and consent. The idea that they would give them their advice, and then the president would reflect on that, and then they propose the action again, and the Senate would act. But it's more consent more than advice these days. Treaties, cabinet officials, and other senior officials designated by law, and federal judges, including the Supreme Court, and had the power of removal of the president upon House impeachment and Senate trial by 2/3 vote. That is, the Senate can't try the president unless the president is impeached by the House. So it's this checks and balance system we have throughout what the Constitution has provided. There was also what's known as the Commerce Compromise, that the regulation of commerce, either with foreign nations or among the states, who would handle that? Would it be like in the original Continental Congress, it would be each state was like another nation, they just negotiate like nations. Well, the great compromise that was made was that the federal government would regulate interstate and foreign commerce, and the states could regulate intrastate, that is, within the state commerce. That's why we have telephone systems that are franchised or authorized by the state and not by the federal government. Why we have state-chartered banks. Of course, the biggest compromise that seemed to always be there was the original sin of America, and that is the sin of slavery. How to handle it? How do you get by that? Could these new politicians rise to the occasion and either end slavery under some circumstances, or at least get a compromise that you could get the government going and put that as unfinished business? And the slavery compromise was not pretty. Slavery is never mentioned in the Constitution. The word slavery is never mentioned. But certainly the wording was there. There was a 3/5 compromise. Slaves to be counted, or indentured persons, were to be counted as 3/5. Slaves defined as property. But for purposes of congressional representation and taxation, when you could allocate, because we didn't have an income tax in those days, and it was by many scholars prohibited. It required eventually a constitutional amendment to allow income tax to occur. 3/5 of a person. Of course, the 3 constitutional amendments that occurred after the Civil War removed that. Slave states gained more House members as a consequence of that treaty. So the southern states didn't have as much population as some of the northern states, such as Massachusetts and Pennsylvania. So they gained power this way through it. And the slave trade, that is, was banned, would be banned 20 years after the Constitution would go into effect. So in effect it said, hey, a generation of slaves, before even the regulation of slavery, not the abolishment of slavery, but just the regulation of having people bring in more slaves, was kicked down the road for 20 years. When you looked at the states at the time of the Constitution, you can see where the slave states included New York. Now, that's because it hadn't been outlawed yet in New York. But slavery occurred in New York. So you had 8 slave states and 5 free states. And then this is not a class in slavery, so we could talk about how it developed over time, but at a different class. I don't know if Professor Dery, is that you out there? I saw a man in a suit. Why don't you come on down and we'll be ready in about 5 minutes. How's that?
I was afraid I was in the wrong.
So they eventually reached the document, and as I said in the summer, we'll talk more about the details of how they got there and the ratification process. The ratification process and the Federalist Papers and the Anti-Federalist is a great story. It's a great story. Great politics, great drama, and we'll cover that in the summer. At the end of the Constitutional Convention, as the door started to open to the public, as a document emerged, Ben Franklin, with gout, is carried in to the Constitutional Convention, as he was every day. He was up to it, health-wise, was brought in, and he gave this speech, and this line is one of the greatest lines, I think, in American democracy. And let me read it to you. Not as Ben Franklin. do with Ben's dialect. There are several parts of this Constitution which I do not at present approve. Arguably, he was a very much an anti-slavery person. Well, I am not sure I shall never approve them. Not slavery, other parts of the Constitution. I doubt, too, whether any other convention we can obtain may be able to make a better Constitution. It therefore astonished me, sir, to find this system approaching so near to perfection as it does. And I think it will astonish our enemies. And then it went to the state. So let's move on to our guest speaker. Let me just give 2 minutes of intro. Privacy in the cyber age. We have the Fourth Amendment, in which the rights of the people to secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants should be issued but with probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized. That's one part of what we'll be talking about today. We have Max Dery, professor here at Cal State Fullerton, a Juris Doctor from Loyola University, bachelor's degree from UCLA. Research areas include constitutional and criminal procedures, Fourth, Fifth, and Sixth Amendment rights. He teaches classes here in criminal law, adjudication and judiciary, courtroom evidence, search, seizure, and interrogation, law, politics, and society. Last year, a book he authored came out called Criminal Law. Doesn't sound like a very exciting title. Just a note to you. We're very pleased to have with us today Professor Matt Dery. And I need to give him a microphone.
I have been here since 1990 after a stretch at the Los Angeles District Attorney's Office. I did a little bit of misdemeanors for 3 months. They needed bodies upstairs, so they moved me up to central felonies in downtown Los Angeles. I had a pulse. That basically was the standard for promotion at the time. After an opportunity came open here, I moved over in 1990. So I've been here since, almost 30 years now. My research focus, as noted, is Fourth, Fifth, and Sixth Amendments. I'm going to focus on the Fourth Amendment today. And in doing so, I'm going to be looking at how advancing technology implicates Fourth Amendment issues. So at one time, I looked at a thing called a cyborg moth. DARPA, the Defense Advanced Research Projects Agency, put mechanics inside of a moth that they wanted to use to hunt down bin Laden. So I thought, what if the police want to use that to hunt you down? What are the Fourth Amendment implications of that? I've looked at millivision, which is a millimeter radiation that looks through your clothing, so it can do a frisk at a distance. Today I'm hoping to look at 2 things, and I hope that I'm cut off in the appropriate time because I tend to talk too much, so that there can be questions. The 2 things that I want to look at today are, one, there is artificial intelligence that is being used with cars. So I think we can advance, I don't know how to advance it. Once again, I have no, okay, so there Fourth Amendment concerns raised by technology. Okay, let's do, could you advance it one more time? I'm so sorry. Okay, here we go. So I've written this article, is a friend truly a friend if you can just leave it in the garage? Toyotas and Honda's concept cars could have significant Fourth Amendment implications. Georgetown took this in their criminal law review. The other thing I'm hopefully going to get to is the Golden State Killer, dealing with genetic genealogy, how a distant relative put some DNA up on the web, and the police tracked him down. But first things first, we're going to look at this car, and I think, let me see, I'm going to go over to my notes here. Oh, look at that. Isn't that kind of cool? So, in 2017, Consumer Electronics Show in Las Vegas, all of these kinds of shows are in fun places, so they had it in Las Vegas. Toyota and Honda, and I'm just going to focus on Toyota. Toyota released a car called the Concept I car, and this had an artificial intelligence inside of it called UI, Y-U-I. I don't know why it was called that, but it's an artificial intelligence that's supposed to make the car grow with the user. So the idea here is that Toyota wants to build customer loyalty. So they want to build a bond between the driver and the car. So they've created artificial intelligence that is very sophisticated. At the convention, they actually had the artificial intelligence speak to the audience. And at one point, the guy, Bob Carter, who was introducing it, was talking, and Yui interrupted and said, you seem a little stressed. Bob goes, well, I'm presenting to all these people. Well, why don't we do some breathing exercise? Okay. So this car is supposed to, so when you walk up to the car, it flashes hello on the side of the vehicle. One of its headlights winks at you. You get into the car, and a little circle, a little wobbly circle comes up, and you're supposed to kind of do a handshake with it. And this is supposed to build trust. It's supposed to give sort of a charm. It's supposed to kind of lure you in and make you a friend of this car. There's a getting to know you phase where you give them access to your social media, your calendar, your phone, tell about your hobbies, all that. And then you drive along, and as you're driving, it collects biometric information on you. Let's see, I want to be particular here. It collects facial expressions, pulse rate, breathing rate, body temperature. I'm not quite sure where the thermometer is. But, tone of voice, driving conduct, and this builds a happiness map. So you're driving along, let's say you're in traffic, and your face is not what it should be, maybe the tone of your voice isn't. So then the car will say, hey, do you want me to take over driving? And you can say, yeah. And then it will recline the seat, and it will massage your back. I don't know if they supply cigarettes, but anyway. Then what happens is it will access your social media and will say, oh, look, we have this huge traffic jam here. Yet one of the restaurants you always wanted to meet is right next door. And it shows that your friend happens to be in this location. Why don't you pull off and have a meal? Or if not, it'll engage you in conversation. It'll play tic-tac-toe with you, that kind of thing. So, and this car gets to be smarter and smarter over the weeks, months, and years. Learn more and more about you, so you become more and more attached to this car. So Toyota says they don't want to just give you a car, they want to give you a pal. Okay? And so the idea here is that you get to a point where you have this great relationship with this car, and it creates a little bit of a problem. And the problem could be that police might want this information. If you hit somebody, okay, with your car and then drive away, or you rob somebody and then drive away. And so they're going to want access to all that information. And if you think about it, you're giving this car information almost sort of unconsciously, and the car could catch you when you're not at your best. You know, you're in traffic, you're late for work, You had a bad day at work. You got in an argument with a family member, you know, and you're behind the wheel, okay? Also, it takes all that information and it associates it with your location so that the police would be able to tell what you were thinking, when you were thinking, in a sense, and where you were thinking it. So what I'm going to do is I'm going to look at what this means for the Fourth Amendment if the police collect this. And in order to do this, we have to look at the Fourth Amendment itself. So, could you advance to the next? This is the other thing I hope to get to. Can a distant relative allow the government access to your DNA? The Fourth Amendment implications of law enforcement's genealogical. Good gravy, that's a long title. But basically, we're going to look at the GSK, the Golden State Killer suspect. Okay, there we go. Fourth Amendment. You've already heard the first part of this. What I want to point out with the Fourth Amendment, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable. We're going to focus. Well, that's terribly unreasonable. Well, you know what? I'm not comfortable with it. I always just use a board. I write on the board because, you know, I'm still in the last millennium. Okay. So anyhow, it says unreasonable searches and seizures. So we're going to look at what a search and seizure is, and we're going to look at what is unreasonable. All right? But first, what we're going to do is look at that idea of what is a search or seizure. And this is important because the U.S. Supreme Court interprets what the Fourth Amendment is. So the Fourth Amendment, as you guys know, is in Wisconsin, the Constitution. It's all happy there, but it's interpreted by the U.S. Supreme Court. So it's not much of an overstatement to say that the Fourth Amendment is whatever the U.S. Supreme Court says it is. So the U.S. Supreme Court has a certain structure for the Fourth Amendment that turns out to be very powerful. It breaks every Fourth Amendment issue down into three parts. The first part is application. Does the Fourth Amendment even apply in the first place? Okay? The Fourth Amendment applies only to searches and seizures. It applies to nothing else. The police come out and they TP your house, okay? And we come out and you look at the TP and they say, loser, okay? It's rude, it's bad, but it's not a search or a seizure, so it's not covered by the Fourth Amendment. That's my, somebody just entered my house. Sorry about that. Yeah, I have the ring on, and I'm not a big ring thing because Fourth Amendment privacy concerns. My wife wanted the ring, so she's crazy. Yeah. Okay, so yeah, the Supreme Court, exactly. So, the first part is application, whether or not there's a search or seizure. If the police act rudely, but they do not commit a search or seizure, the Fourth Amendment doesn't even apply. Sorry, I can't listen to this anymore. Okay, it won't be next to all the microphones. So the next thing that they look at is violation. You can only get to Fourth Amendment violation if the Fourth Amendment applies in the first place. Violation focuses on unreasonable. If the police are doing a search or seizure, but it's reasonable, so the bottom line is, if they act unreasonably, then that's a Fourth Amendment violation. Reasonably, no problem. If they're unreasonable, like lack of warrant, lack of probable cause, something like that, then it's a Fourth Amendment violation. The third is remedy. The third part of the structure is remedy. And typically, although not exclusively, that means the exclusionary rule. If you violate the Fourth Amendment, they will exclude the evidence that you obtain by virtue of the violation. Okay? So those are the three parts. We're going to focus on Fourth Amendment application search. Okay? What I would ask you to think about for a moment, just a little hypothetical. Let's say you go to the bank. You go to the bank, you go in to take out $200. You're withdrawing $200. Will the teller say to you, oh, you didn't pass go? No, they'll never say that. You only have to pass go to get $200 in Monopoly. You guys with me? You guys with me? So monopoly rules only apply when you're playing Monopoly. Okay? It doesn't apply in the real world. By the way, this does not work for my students. They don't know what Monopoly is. They think I'm a complete loser for playing a board game. Okay? But anyhow, so the idea here is the Fourth Amendment only matters when it applies in the first place. So it applies to a search or a seizure. So, do you have a search when police take information from your Concept I car, this Toyota car? It all depends on a case called Katz versus United States that gives us one of the two definitions of a Fourth Amendment search. Basically what happens is a guy is in a phone booth, which is another concept I have to explain to my students. He's in a phone booth, closes the door, puts in money, and makes a call. He's transmitting wagering information from Los Angeles to Boston and Miami. You know, put $100 on my dad George IV, that kind of thing. The FBI has placed a bug, an electronic listening device on top of the phone booth, and they collect his side of the information. And then they prosecute him for it. He tries to get that information kicked, arguing, hey, I was in a phone booth. And the FBI says, hey, it's a public phone booth. You don't have reasonable expectation from it. You don't have any privacy in that. So there was a big back and forth, and the U.S. Supreme Court said that ultimately Mr. Katz was right. He had privacy once he puts in that dime. He has privacy once he shuts that door. Once the little fan turns on, he has privacy in the contents of his conversation, and the FBI intruded upon that. But what they came up with was a reasonable expectation of privacy standard. Whenever one, the government intrudes, two, on a reasonable expectation of privacy, one that is held by the individual, okay, and one that society is prepared to recognize as reasonable, that is the search. We all have expectations. We have an expectation that this class will ultimately end. If we were to seal the doors, you'd be upset, okay? All right. So we have expectations. The expectation here is one of privacy. Imagine if you are showering at home, okay? And as you're showering, Wolf Blitzer suddenly comes in, pulls back the curtain, and they stick in one of those cameras, and Wolf Blitzer says, I haven't seen this kind of action since Iraq, okay? Now that, you would feel like your privacy has been invaded. And society is prepared to recognize that as reasonable. We need certain places where we need to be left alone, okay? If instead you were, stripping naked on the lawn and taking a hose, and when people walk by, oh my gosh, you just said, quit looking. You have no right to look at me. Your privacy expectations would be unreasonable. So what we're looking for is a violation of a reasonable expectation of privacy. That's a search. So when it comes to this car, what privacy expectations are going to be accepted by the court, okay? And this all depends on how the court frames this issue. Is it an issue dealing with this car as a false friend because you're making a friendship with this car? Or is this an issue? Oh, you're shaking your head no. Well, I guess we're done. All right. Or is this car really a smartphone on wheels? They've already made a decision with smartphones. I'm going to go with the unlikely one first because it's kind of interesting to me, and really it's all about me in this lecture. So what we're going to do is we're going to look at that false friend precedent. It turns out that the U.S. Supreme Court has already dealt with people who made... Oh, yes?
Can you waive your Fourth Amendment rights?
Yeah, well, they don't technically say you can waive it, but you can give consent. You can say, can I search that bag? Sure.
Maybe the Toyota had you sign on the dotted line.
I don't consent is a much looser concept than waiver. And the U.S. Supreme Court is a little uncomfortable about waiver. I would say this to you, though. They would look at it this way. In Cass, that case we just talked about, they said, well, you can have privacy in public places like the phone booth. You can undermine your reasonable expectation of privacy even in your own home. What if you knocked out all the walls and, vacuum naked? All your neighbors see this, okay? So you have no reasonable expectation of privacy in that. So you can undermine your Fourth Amendment rights. But I haven't really seen a case of waiver. That's probably a brilliant question, and I don't have a brilliant answer. All right, so the bottom line is, but questions are welcome, okay? I rarely get them in class. Usually at this time they're inside kind of a coma. So when we're looking at the false friends precedent, there's this case called U.S. versus White. And what happens is a guy named Harvey Jackson, who's a government informant, goes into James White's home, and they talk about all the drugs that they're sending back and forth. Sometimes Harvey Jackson is wired in White's home, and so that information is being broadcast to the police. Other times, they're in Harvey Jackson's home, and the government agent is literally hiding in the kitchen cupboard. I'm sure eating donuts. Anyway, so the bottom line is that later on, White says, I confided in a friend here, and you're taking that information that I gave you and prosecuting me with it. And what the U.S. Supreme Court said was, essentially, there's no honor among thieves. That if you tell your co-criminal incriminating information, you're assuming the risk that that co-criminal will turn around and tell it to the police. So what is the concern about that with this car? And before you dismiss it outright, let me give you some ideas about the danger of the gap between what Toyota is selling as a friendship and what the police would do under the Fourth Amendment, how the U.S. Supreme Court would interpret it under false friends precedent. Okay? There's this thing called anthropocentrism, something, okay? And I knew I screwed up. So, but what it is that we humans, as sort of an evolutionary defense mechanism, see mind everywhere, okay? And this is, there's these authors of this book called The Mind Club, and they speak about how, and you guys have seen, you know that Tom Hanks movie, Outcast? Cast Out? Okay, so he's on this island, and he makes a volleyball. Wilson is the brand of the volleyball, okay? And he connects to this volleyball because he's got nobody else, okay? There's also been studies with a thing called clocking. It's an alarm clock. And what it does is in the morning, it goes off and then it rolls away when you try to turn it off. That's how they get you out of bed. Okay? There's this hugging pillow that hugs you back. Okay? So they did studies with the pillow and with clocking. And people will interpret in mind into these physical entities. The lonelier you are, the more likely you're going to do this. It happens on an unconscious level. If you don't think this happens, think about your pets, okay? You know, I have 3 cats and a dog, and they're all, nuclear physicists compared to me. They've got me doing all everything. So, there's also this thing with this computer. Yes? Oh, there's also, yes. There's this test with the computer. The computer purposely does something wrong over and over again, and then asks for a survey. People, when responding to that computer, are very polite. You did a wonderful job, heck of a job. And then when they give the survey to a second computer, they trash talk the first computer. They don't want to be rude to the first computer, but they do gossip about it. So there's a lot of this. So what if people rely on this to their detriment? give all this information, and then the police gather it up through false friends president. Yes?
Isn't there a way to have a driverless car without artificial intelligence?
Oh, yeah, in fact, that's Google and, Uber and all those, that's exactly it. So this is Toyota trying to allow the driver to still be involved in the driving process if they so choose. This is also, quite frankly, right, Toyota's in the business of selling cars. And so if they make you attached to a car, then if you sell it, it's going to be a breakup. Right, so you're just thinking, it's transportation. I agree with you fully. You sell it too, but once it's out, it's gone. Yeah.
Aren't you pointing to a real dilemma? That is, as the younger generation grows up with Facebook and so on, what constitutes reasonable privacy changes? What I think should be private, my grandchildren laugh at.
Exactly. In fact, think about it. I don't know how much, I'm not on Facebook because I really don't have anything to brag about. But if you hit, there's an agreement. When you ever on the computer, so you just hit. You really read all that stuff? Boilerplate. It's like a car contract, right? You just hit yes. And I talk to my kids about this. They just hit it. They don't care about their privacy until something horrible happens. And so it's this up, down, kind of sporadic, where they're not really focused on it. And so that's actually leads me, I do want to address, I was going to say it leads me into the GSK killer. But before I get that, I should probably give you the smartphone on wheels. And that basically is, there's this case, Riley versus California, where the police arrest a guy, this is dealing with the smartphone issue, I think this that. Arrest a guy for possessing firearms under the hood of his car. Okay, I'm not quite sure why you would store a firearm under the hood of your car. It doesn't really seem like a good place to put them, especially if it gets too hot, but whatever. So they arrest the guy, they get a hold of his smartphone, and they scan it. And they realize that, there's gangs out there, Crips and Bloods, and he's a gang member because whenever he spells something that would only have, now I can't think of an example, but only would have either a C or a K in it, he'll add in the missing consonant, so it's always CK, so it would be Crip Killer. Okay? I can't think of anything. Pricing? Well, no, that's a bad one to come with, but I don't know where that would go. Anyhow, so CK is, and so they figure out this guy is a gang member, and they ultimately attach him to some bad stuff. So it turns out that the police have always been allowed to search you whenever they arrest you, even though there's a warrant requirement. Get a warrant or explain why not, because police and DA, when I was DA, we were all, foaming at the mouth, trying to get killers, so you cannot trust us to be unbiased. So you go to a neutral third party, you go to that judge, and with sober second thought, they give you permission to do a search. That's the standard requirement. But when it comes to arrests are so dangerous, they're so dicey. You're arresting somebody who doesn't want to be arrested. They might have evidence for the crime. They might have weapons that they could use against the police officer to resist arrest and escape. The police are automatically allowed to search instant to arrest. So they can search your pockets, get your wallet, get your keys, get your guns, your drugs, whatever they find. But what about that phone? The U.S. Supreme Court had to decide whether or not the police could search that phone incident to an arrest, or were phones so different now that you needed to get a warrant. The U.S. Supreme Court realized that phones carry vast amounts of information, okay? They say comparing a phone to to other kinds of, like a notepad or something, other non-digital information. Just like comparing, the moonshot to the Pony Express. Okay, they both get you there, but completely different ways. So, the vast amount of information and all of the different things that phones do now, they are calendars and TVs and dating devices, encyclopedias and social networks and all the rest, means that there's just too much information in this phone to not require a warrant. So, if you're going to search a phone, you got to get a warrant. It falls outside the search incident to arrest exception. Now, we're not dealing with search incident arrest here, but we can analogize. We can say, if police wanted to search your car, they would make that same kind of distinction between what they call real physical evidence and what they call digital evidence. And the car would fall into digital evidence. So you see how you get a different answer if you ask a different question? Is this a false friends case? You're out of luck. Is this a smartphone case? You're in business. You don't have the Fourth Amendment bother. Yes, sir.
Your cell phone would also indicate where you've been. Your cell tower.
Exactly.
The time you were there, and your car has a computer that says whether or not you stepped on the brake or.
Exactly. Right, and it has a GPS function. But you're referencing a case with the cell phone sites called Carpenter versus the United States. Just came down last summer. And the court said that this was such a vast leap in collection of information that it was a search requiring a warrant. That when police go to cell tower sites and collect the information that shows that you were near this cell tower, that is something that requires a warrant. Before that, simply following you on the road, following your car, would not be sufficient for a warrant in and of itself. So that's the distinction of the level. It's a difference in degree that is so great that it's a difference in kind. Yes?
If the police secure a warrant to search the car, concept car, to search its physical inside, does that also allow them to search the artificial intelligence that it has acquired on you, or must they obtain another higher level smartphone warrant?
My guess is they would just include those specifics in the original warrant. The warrant has to, the second part of the Fourth Amendment gives you a recipe for how to cook up a warrant. And it says particularly describe the places to be searched or the persons or things to be seized. So it requires particularity and description. So that particularity and description could include, breaking into the artificial intelligence. Now, I don't have a case on that, but that I think I'm pretty firm on that. So the bottom line is as you guys may know, about a year ago, last spring in Sacramento, the Sacramento District Attorney announced that they had finally found the Golden State Killer suspect, Joseph D'Angelo, a former police officer. And the Golden State Killer, absolutely horrible person. Well, I should not just throw out numbers here. 12 killings, 50 rapes, 100 burglaries from 1974 to 86 in Sacramento, Santa Barbara, Ventura, and Orange counties. He would be methodical. He would call ahead of time to learn victims' routines. He would cut phone lines. He would unplug air conditioners so he could rape at his leisure. He hit one neighborhood so many times that people had to sleep in shifts. This killer was awful. And so they couldn't solve the case. They even had him in the backyard one time. They were running after him and somehow just disappeared. Okay? And he said, he knows how to get away. So what happens is that they used genetic genealogy to track him down. Basically, how many people have ever done National Geographic, 23andMe, Ancestry.com? Okay, so they give you a little tube, you spit in it, and then they tell you all about yourself, okay? They have strict privacy protocols, okay? those are pretty well buttoned up, okay? It's going to need a warrant to crack those. But you can take the results and you can go to a thing called GED match, okay? And this is for hobbyists who like to build family trees. It's for adoptees who are looking for their parents. It's for people who are just trying to connect with family. And you upload your DNA onto the internet. And GED match very clearly says this is not private. So they tell you right away, it's not private. It's the only way you can connect with other people, right? And so the police took crime scene DNA, and they got a partial match with the great-great-great-grandfather of the Golden State Killer back in the 1800s. They built these huge genealogical maps, these family trees, 25 different family trees. They went to census records and obituaries and hunted it down to this one guy. They go and collect DNA from a door handle from his car when he goes into a Hobby Lobby. And they confirm it again with tissue at his home, and then they arrest the guy. So if you think about this, you know, how many, I have this tie that shows a little black sheep on it, okay? And how many of us have black sheep in our family? How many of us are the black sheep? So the bottom line is that what's going to happen if somebody you don't even know, a relative of yours, uploads their DNA. When they upload their DNA, they're uploading a huge amount of your DNA. Now they are giving consent, okay, saying, okay, anybody can look at this, but are they giving consent to the tens, hundreds, thousands, tens of thousands of family members who are not there, okay? They're not clearing it with all those people. So there's this question of consent. So the bottom line is, how many I'm probably pretty much dust right now, right?
You have about 8 minutes.
8 minutes. So the bottom line is that there's many ways to look at this. One of which is third-party consent, okay? It's one thing if somebody says, if a police officer asks, can I search your bag? And you say yes. But what if somebody goes to your house and you're not home? Ding dong, hey, can I search the house? And somebody in that house says, sure, okay? That third-party consent, not first or second party, it's not the police, it's not you. It's that third-party consent can be valid if that person has what's called common authority based on mutual use of joint access. You assume the risk this person will let in other people, including the police, all right? The problem is a Matlock case. The problem with Matlock is that you're not really assuming a risk when somebody is using DNA that you're sharing with them. DNA is a cellular process that you have no volition or control over, so you're not saying, okay, I'm going to divide these two cells. That was hard. You don't do anything like that. And so it's all, and so that part is not really subject to this assumption of the risk analysis. There's these other cases that say, there's Randall and Fernandez, and they deal with when one person says yes and another person says no. The court uses social norms, okay? If the objecting party is present and says, I know my rights, you're not coming in, even if their wife says, come on in, okay? Police are not supposed to go in. They can't use any evidence obtained against the objecting party. But if they go up to the house, ding dong, I know my rights, you're not coming in, but the police have probable cause to arrest that objector, they can hook him up, take him to the station, come back for a do-over. Ding dong, hey, now he's gone, can I come in? Sure. So, how does that work when you are not present? Think about that in terms of this genetic genealogy. You're not going to be at every single website for all the thousands of relatives that you can't stop every single person at every single computer. So there's going to be computers where you're an absent objector, okay? So the US Supreme Court precedent really doesn't help you there. Ultimately, what we would do is look at the social norms, and this is where we got into the problem that we talked about before. This technology is so new that we really haven't built a societal consensus on what is private and what is not. Particularly with the youth, they don't respect privacy because they never really had it in the first place. So they don't know what it means. And so they're much more likely to give it away. So we're not going to, so there's really a concern about this third-party privacy. And I think I'll leave it at that for a question.
Okay, questions? Go for it.
Yes.
Dad, if your
Car.
arrest versus, okay, if a police stops you in a car and he wants to search your car,
Yeah.
he has to, what?
So the police officer goes up, and by the way, there's a whole little drill here to make sure, they come up and they go, hey, you don't have anything illegal in your car, do you? Oh, no. Oh, so you wouldn't mind giving me permission to search it, would you? Now that's awkward. Or they'll say, oh, I was going to stop you for a ticket, but I'll just give you a warning because, I'm such a wonderful fellow. By the way, can I search your car? So there's all sorts, there's that human interaction that they're manipulating. But anyhow, be that as it may, let's say, can I search your car? And then you say, I'd rather not. I'm in a hurry. Oh, this won't take any time at all. I'm always thinking, well, it'll take less time if I just leave, okay? But, I always suggest that you make the police officer's day as good as possible by being polite as possible, right? There's a thing called the attitude test. It's unofficial, but you want to pass the attitude test. I know all my Fourth Amendment rights, but I'm still, yes, sir, yes, ma'am, okay, whatever you want. But when it comes to consent, I haven't been asked yet. But, and I don't know what I would do. I probably, start out with saying, quite frankly, Fourth Amendment, it gives me privacy. I didn't do anything wrong. I know I didn't do anything wrong. I got places to go. That's why I'm in this car. So I'm going to go. Unless you're going to stop me for some reason,
Can he arrest you and then?
Well, you got to have probable cause for the arrest, right?
So you say no, and he says, well, I'm going to arrest you then.
Well, you cannot use the refusal as information towards the arrest because it's ambiguous. It could be that you're refusing because you're guilty of sin, or it could be that you're refusing because you want to use your Fourth Amendment right. So it doesn't give them any extra information. Yes, oh, sure.
In the case of this car, though, the information that I share with the car is like the information I would share with my cell phone or my computer.
Yes.
That is mine. That's my goods. It's my property. So unless the car does something bad.
I never thought of that. How do we know it won't go, but it will be how?
That's right. But it's still mine.
That's true. It is still your property, and so then, but so is your house. But if you expose your behavior in the house, then you can still lose your Fourth Amendment rights in your house. It's pretty rare, but it could be. Yes.
Let's say you have a couple $1,000s in cash in an envelope on your front seat.
Well, this
And I know
sounds
this
like
has
it's a personal
happened
story.
because.
Can I drive with you?
But you got it legitimately. Then they go through this asset forfeiture routine where they say, oh, this is probably ill-gotten gains from a drug deal. We're keeping this money. And I know there's a case just recently decided.
Just came down. Excessive fines. I think it's T-I-M-B versus Indiana. Yeah, and I'm very excited about this because it may have implications that overturn a case called Bennis versus Michigan, where it was an asset forfeiture. A man drove his wife's car for an assignation with a prostitute. He's arrested. They take the car. It's her car. That's going to test the marriage. So, court back then backed up the forfeiture. In light of Tim's, I don't know if that would happen anymore. That may be different now.
A drone flies over a backyard, a bunch of bad dudes are sitting around just talking, they're not using their cell phones, but they assume that they're private. But the drone is got a microphone on it and they're doing a drug deal. Is that something that they could use or not?
Two cases leap to mind. California versus Sorrello, it's a plane overflight at 1,000 feet. And Riley, Florida versus Riley, which is a helicopter at 400 feet. And it would apply to observations rather than listening, but observations were allowed. So I'm thinking now that drones are so prevalent that you might have trouble there. It depends on, you know, how loud was the conversation. In other words, you know, the first house I had a postage stamp for a backyard, and everything we did in the backyard, the neighbors could hear. So I don't know if I would have reasonable expectation of privacy when I'm saying, honey, help me bury the body. Whereas with, you know, if it's a larger estate, it may be something where you have more likelihood of reasonable expectation of privacy. So I'm going to dodge that one and leave it with Max. Oh, look at the expression on your face. Max didn't answer that.
Quick question. You mentioned earlier that you had to have a separate to get it, on the phone plus the car, correct? What about when you go through security?
Well, when you go through security,
They tell you to put all your stuff in their little bucket. They pass it through the thing.
there's a thing called special needs. And so schools, nuclear facilities, laundry trucks into prisons, planes, nuclear reactors. This is stuff that is so intense that the government, the court may not apply traditional probable cause going requirements. They may instead apply special needs where they balance the benefits versus the costs, okay? And so that's why every time I take off my belt and I'm sitting there, I feel like a prisoner holding up my pants. I know they consider it special needs. I will say though, you know, I want that plane to land and not drop out of the sky. So because of that you can almost sense that gut reaction. They're going to say that in special needs, that's why the TSA can do those intrusive searches.
Professor?
Yes.
Thank you very much. Let me add that you provided not only great legal scholarship today, but you're one funny guy. Let everyone know that you're an outstanding example of the quality of the faculty here at this university, and as part of the taxpaying public and with a granddaughter who attended and graduated from this university recently. We're very proud of you. Okay, a couple of end notes. My wife is, she's back. I said my wife has disappeared to go make coffee for this class. But when my wife is away next Thursday, reasonable expectation of assignation. But my wife is away next Thursday. I do need some help on coffee. Yeah, a week from Thursday. That's right. So wait until then. This Thursday's too soon. This class returns after the Easter break on April 9th. We'll have more of Professor Campbell's interview. Next Thursday, a week from Thursday, is the Trump presidency. I think the Mueller report is going to be out by then, I anticipate we'll have a lot to talk about. I just anticipate. And we'll also use a little bit of Professor Campbell's interview to talk about the powers of the Congress to do investigations. And it's not a black and white situation, it's law, right? It's not black and white, so we'll have part of that interview. Our Money News comes back on March 19th, so we'll have a whole series of classes coming up. I hope you'll join me, and thank you for being such a great audience today.